Mr. Stevens.
Mr. Chief Justice, may it please the Court. The issues which are raised by the Bowman cost study are materially different from those raised by the Borden study. And for that reason, I shall of course be talking only about the aspects of the case which are unique as to Bowman. To start with, I'd like to call the Court's attention to the first graduated discount schedule which Bowman put into effect in January of 1953, which is found at page 311 of the record. The record shows that the time studies on which the independent cost experts employed by Bowman calculated their cost curves were conducted in 1949. I thought it was clear in the district court that there was no dispute over the fact that our basic cost studies had anticipated the litigation, had been made in advance, and that the cost curves were subsequently developed. I think that's shown in a colloquy at pages 90.
May I ask one other procedural question?
May I ask you one question? May I ask just one other question? May I ask another question? May I ask just one question about the statute? May I ask you a question? Supposing I ask on that. Judge Posner said that on that one point. May I ask you one narrow question? May I ask you this question, Mr. Schwartz? May I ask this question? You rely very heavily on Ruckelshaus, which of course was a case.
When Justice Stevens retired in 2010, he was really known as the leader of the liberal wing of the court. In fact, he was frequently referred to as the most liberal member of the Supreme Court. It's interesting to look back on his tenure, though, and remember that he was nominated by a Republican president and that he himself did not believe that he had changed much at all over the years of his on the court in terms of his ideology. Instead, he would say, and did say, that the court changed around him. Now, there were some areas in which his opinions did shift, the death penalty being one, but overall, he would say that it was the court that changed, not him. Even in his later years, we see evidence of this kind of multidimensional, not easily stereotyped approach to judging in some of the opinions that he wrote that perhaps surprised and disappointed some of his liberal admirers. One, for example, is the Indiana voter ID case of a few years ago, in which he wrote the majority opinion holding that the Indiana could require voter identification at the polls, at least under the circumstances and in the posture that the case presented itself. I think he also reached conclusions like that were perhaps somewhat contrarian, in part because he really was not an ideologue. He believed in looking at each case and each issue on its own merits, evaluating the arguments, evaluating the facts, and reaching the conclusion that those arguments and facts led him to reach in each individual case. He, at the same time, was not particularly worried about slippery slopes. In other words, he thought that judges could find ways of distinguishing one situation from another, and that allowing something that might, in some situations, be seen as unpopular, for example, does not necessarily mean that the same logic would be applied to a future circumstance that might be perhaps require a different outcome. There were other areas, of course, in which Justice Stevens was known for really leading the liberal wing of the court. Most recently, perhaps, he's best known for his opinions in the Guantanamo detainee cases, in which he insisted that the detainees were entitled to due process protections that as detainees of the United States government.
I have the disposition to announce in number 05184, Hamdan against Rumsfeld. Petitioner, a foreign national held in custody in an American prison at Guantanamo, has been charged with one count of conspiracy to commit, quote, offenses triable by military commission, unquote. He concedes that a court-martial convened in accordance with the Uniform Code of Military Justice, or of course a civilian court, would have jurisdiction to try him, but he contends that the military commission convened by the President lacks such authority because the charge does not allege a violation of the law of war, and the Commission's procedures violate both the UCMJ and the Geneva Conventions. The admitted deviations from court-martial proceedings in this case are not justified by any evident impracticability. There is no suggestion, for example, of any logistical difficulty in securing properly sworn and authenticated evidence or in applying the rules of evidence that apply in courts-martial. The danger posed by international terrorism, while certainly severe, does not by itself justify dispensing with usual procedures. Because the procedures adopted to try Hamdan do not comply with the uniformity requirement of Article 36B, we conclude that the Commission lacks power to proceed. For similar reasons, the Commission lacks power to proceed under the Geneva Conventions, which are part of the law of war under Article 21 of the UCMJ. Common Article 3 of those conventions, which we hold applicable to this case, prohibits the passing of sentences without previous judgment by a regularly constituted court, affording all the judicial guarantees recognized as indispensable by civilized peoples. As Justice Kennedy explains in his separate writing, the regular military courts in our system are the courts-martial, established by congressional statute. Of course, Articles 21 and 36 of the UCMJ envision the use of military commissions, but they also place constraints on that use. At a minimum, a military commission, specially convened by the President, can be regularly constituted only if some practical need explains deviations from court-martial practice. As I have said, and as Justice Kennedy elaborates further in his opinion, no such need has been demonstrated here. We conclude that the Commission violates Common Article 3 in another respect because its rules permit exclusion of the accused from his own trial and prevention of his access to evidence against him. At least absent some express congressional provision to the contrary, customary international law requires that a defendant be permitted to see and hear the evidence against him.
One of Justice Stevens's most heartfelt opinions came in the Citizens United case from a couple of years ago. There, the majority said that the First Amendment gave corporations a right to spend unlimited amounts of money to influence elections. And Justice Stevens wrote a very powerful dissent for 4 members of the court. There he said that it was a real mistake to equate corporations with natural persons. Corporations have no thoughts or beliefs or feelings. They have no consciences. And he says that they're not really members of the political community in the same way that natural persons are. And Justice Stevens said that far from promoting the democratic process, that opening the floodgates to corporate money in election campaigns might very well undermine the democratic process by drowning out other voices and by discouraging people from taking part in the process. Opinion polls have consistently shown that an overwhelming percentage of the American people agree with Justice Stevens about this. And I think in that sense, you can say that he understands the American conception of free speech better than the majority did in Citizens United. Justice Stevens has always resisted mechanical approaches to the First Amendment. The prevailing view on the Supreme Court is that the government can almost never restrict speech based on its content. That is, based on what the speaker is saying or the impact that it might have on the audience. And Justice Stevens has always thought that this is too absolutist an approach. In a number of very thoughtful opinions, he said that to decide whether speech is protected by the First Amendment, you always have to consider both its content and its context. So, for example, in a well-known case called Young against American Mini Theaters, Justice Stevens said that a city could use its zoning power to prevent the concentration of adult movie theaters that might run down a neighborhood. Justice Stevens has been a very strong defender of political speech. One of his best-known opinions is called Claiborne Hardware from the early 1980s. There, the state courts of Mississippi had ordered the NAACP to pay millions of dollars in damages to white merchants to compensate them for business that they had lost during a civil rights boycott. And Justice Stevens wrote an opinion for a unanimous court that said that this kind of a civil rights boycott was political speech that is right at the core of the First Amendment. At the same time, Justice Stevens doesn't think that the First Amendment always trumps all other social values. So, for example, in a case called Hill against Colorado in 2000, he said that the state of Colorado had the right to prohibit intrusive and harassing speech directed at women who were trying to enter an abortion clinic in order to protect their privacy and their emotional well-being. In a couple of well-known cross-burning cases, Justice Stevens has said that, that the state can restrict certain kinds of hate speech in order to prevent the very serious harms that he thinks come about both to the targets and also to the community as a whole. Interestingly, Justice Stevens dissented in the two flag-burning cases. He said that the government should be allowed to prevent the burning of the American flag on the grounds that it's a uniquely important symbol in American life.
The right to free speech, of course, includes the right to attempt to persuade others to change their views and may not be curtailed simply because the speaker's message may be offensive to his audience. But the protection afforded to offensive messages does not always embrace speech that is so intrusive that the unwilling listener cannot avoid it. In a case decided in 1921 in a very different context, Chief Justice Taft explained the interest of the unwilling listener in this language. How far may men go in persuasion and communication and still not violate the right of those whom they would influence? In going to and from work, men have a right to as free a passage without obstruction as the streets afford, consistent with the right of others to enjoy the same privilege. We are a social people, and the accosting by one of another in an inoffensive way and an offer by one to communicate and discuss information with a view to influencing the other's action are not regarded as aggression or a violation of that other's rights. If, however, the offer is declined, as it may rightfully be, then persistence, importunity, following, and dogging become unjustifiable annoyance and obstruction, which is likely soon to savor of intimidation. From all of this, the person sought to be influenced has a right to be free. The unwilling listener's interest has been repeatedly identified in our cases. It is an aspect of the broader right to be let alone that one of our wisest justices, Justice Brandeis, characterized as the most comprehensive of rights and the right most valued by civilized men. The Colorado Supreme Court was correct to conclude that this regulation is a content-neutral time, place, or manner restriction. It was not adopted because the state disagreed with any particular message, and the state's interests in protecting access and privacy are unrelated to the content of the demonstrator's speech. Petitioners nevertheless argue that the statute is not content neutral because an individual near a health care facility who knowingly approaches a pedestrian to say good morning or to randomly recite a few lines from a novel would not be subject to the statute's restriction of oral protest, education, and counseling. This argument is misplaced. It is common in the law to examine the content of a communication to determine the speaker's purpose. Whether a particular statement constitutes a threat, blackmail, an agreement to fix prices, a copyright violation, a public offering of securities, or an offer to sell goods, often depends on the precise content of the statement. At most, the necessary review under this statute need be no more extensive than a simple determination of whether a general prohibition of picketing or demonstrating applies to innocuous speech, which we have never found constitutionally problematic. The Colorado statute's regulation places no restrictions on and clearly does not prohibit either a particular viewpoint or any subject matter that may be discussed by a speaker. It applies equally to used car salesmen, animal rights activists, fundraisers, environmentalists, and missionaries. Each can attempt to educate unwilling listeners on any subject, but without consent may not approach within 8 feet to do so.
I had the privilege of clerking for Justice Stevens for 2 years, from 1990 to 1992. And it was such a great experience after the first year that I asked him if I could stay a second year. And I would say that the best part of the day for every Justice Stevens law clerk was first thing in the morning. The justice would come in to the clerk's room, and he would sit on a very big leather chair with a cup of coffee, and we, the law clerks, would of course be there, and no matter what time it was. And we would start by talking about sports, even for those of us who know nothing about sports, or about news of the day. And then we would talk about the cases and about the opinions and what problem areas there were. And it was just a very nice time to chat before the activities of the day. And that's something that I miss now that I've left, since I've left the clerkship. I would say that the clerkship was a remarkably collaborative time. Justice Stevens, as you know, was the only justice who would write his own first draft of the opinion, which meant that he would deliver the opinion to the clerks very quickly, and then it was our responsibility to fill it in, to work on footnotes, to suggest edits, but there was a real back and forth, and he made all the law clerks feel that they were adding value, that they were contributing. And it was, you would see his eyes light up when you return the draft to him, because he was so quick and we were so slow, and we hated to hold him up. And then he would come back again with his changes, and there was just this wonderful back and forth. And so the writing was a tremendous opportunity. Of course, you wanted to make sure that you didn't make any mistakes. You knew that everything you did counted. There are a number of lessons that I take away from that clerkship that I use to this day. One is Justice Stevens' optimism, which was just so inspiring. He would come back from conference and the vote would be 8-1, and he'd be the one, and he wasn't despairing at all. We, the law clerks, would be totally depressed, but he really always was upbeat, and he assumed that, you know, some other justices might join his opinion, or if that didn't happen, he encouraged us to take a long-term perspective and to realize that when you write a dissent, you're explaining your views to the parties, which is important, but you're also writing for the future. You're writing for future litigants. And in fact, at some point, the court might revisit the issue in a different context, and your dissent might serve as the basis for a majority opinion. Another lesson that I took away was the importance of Supreme Court practices that are hard to discern or understand from the outside, but that when you work in the court, you really see them at play and learn how important they are. One is that the justices shake hands before oral argument. And I think this is so important for collegiality, so that no matter how much you might differ when you're on the bench, you know that you put those differences aside when you're in the same building together and working together for so many years. Another practice that I learned about that's really important is when it was important for the justices, at least one justice, to dissent each term from the bench. So if you were dissenting, you decided whether you wanted to also offer your dissent from the bench. And the reason for that is that it conveys the quality of the disagreement and sometimes the extent of the disagreement in ways that words don't always do. Two of my colleagues, Carolyn Shapiro and Chris Schmidt, have worked on a paper on that very topic. And on the last day of the term of my second year, Justice Stevens dissented from the bench in a case called Payne against Tennessee. and it had to do with the prosecutor's use of victim impact statements in death penalty cases. And the court held that it was okay for the prosecutor to use them. And Justice Stevens strongly disagreed, and he had a very strong dissent from the bench. And he writes in his book, Five Chiefs, Supreme Court memoir, that he still feels strongly about that case to this day, 20 years later.
Insofar as the court's jurisprudence is concerned, this type of evidence made its first appearance in 1987 in Booth against Maryland. In his opinion for the court in that case, Justice Powell noted that our prior cases had stated that the question whether an individual defendant should be executed is to be determined on the basis of the character of the individual and the circumstances of the crime. Relying on several recent cases, the court concluded that unless evidence has some bearing on the defendant's personal responsibility and moral guilt, its admission would create a risk that a death sentence might be based on considerations that are constitutionally impermissible or totally irrelevant to the sentencing process. Evidence that served no purpose except to describe the personal characteristics of the victim and the emotional impact of the crime on the victim's family was therefore constitutionally irrelevant. Today, however, relying on nothing more than the dissenting opinions in Booth and Gathers, the court abandons rules of relevance that are older than the nation itself and ventures into an uncharted sea of irrelevance. Today's majority has obviously been moved by an argument that has strong political appeal, but no proper place in a reasoned judicial opinion. Because Chief Justice Berger's opinion for the plurality in Lockett against Ohio recognizes the defendant's right to introduce all mitigating evidence that may inform the jury about the character of the defendant, the court suggests that fairness requires that the state be allowed to respond with similar evidence about the character of the victim. This argument is a classic non sequitur. The victim is not on trial. Her character, whether good or bad, cannot therefore constitute either an aggravating or mitigating circumstance. Even if introduction of evidence about the victim could be equated with introduction of evidence about the defendant, the argument would remain flawed in both its premise and its conclusion. The suggestion that exclusion of victim impact evidence results in a significantly imbalanced sentencing procedure is simply inaccurate. Just as the defendant is entitled to introduce any relevant mitigating evidence, so the state may rebut that evidence and may designate any relevant conduct to be an aggravating factor, provided that the factor is sufficiently well defined and consistently applied to cabin the sentencer's discretion. In its groundbreaking decision today, the court makes no effort to identify the limits on the prosecutor's use of victim impact evidence. The majority also argues that its novel rule is appropriate to enable the jury to take into account the fact that each murder victim is a unique human being. But in my opinion, the fact that each of us is unique is a proposition so obvious that it requires no evidentiary support. What is not obvious is the way in which character or reputation in one case may differ from that of other possible victims. Evidence offered to prove such differences can only be intended to identify some victims as more worthy of protection than others. Such proof risks life or death decisions based on the same invidious motives as a prosecutor's decision to seek the death penalty if a victim is white, but to accept a plea bargain if the victim is black. Given the current popularity of capital punishment in a crime-ridden society, the political appeal of arguments that assume that increasing the severity of sentences is the best cure for the cancer of crime, and the political strength of the victims' rights movement, I recognize that today's decision will be greeted with enthusiasm by a large number of concerned and thoughtful citizens. The great tragedy of the decision, however, is the danger that the hydraulic pressure of public opinion that Justice Holmes once described and that properly influences the deliberation of democratic legislatures has played a role not only in the court's decision to hear this case and its decision to reach out to decide a constitutional question without even pausing to consider affirming on the basis of the Tennessee Supreme Court's rationale, but even in its resolution of the constitutional issue involved.